All right. Bring them in, please. Are y'all comfortable with me excusing alternates?
Yes, ma'am.
So you mean excusing them outright?
No.
No? Okay.
I mean, if they sometimes.
That's fine.
Yeah, maybe not.
Ladies and gentlemen, we're going to let you take a lunch break. It's 12:25. I'm going to ask you to be back about 1:30-ish. If you're back before that, all 12 of you can start deliberating whenever all 12 of you are back. If somebody's late, don't start until everybody's back, okay? I know I've said it, but I say it every time. Don't talk about the case. Don't let anybody talk about it with you. Don't review any of the TV coverage or what have you. Go get a sandwich and we'll be looking for you to come back about 1:30. We'll stand in recess, or y'all can be excused. You guys hang on. Y'all can be excused. Go ahead and get him out. I'm going to let him get that meeting started. Okay. They want to, the foreperson handed the bailiff a note on the way out the door for lunch. This is, I think this is 8 because the lunch was 7, I think. No, it's 8 and 9, I think. I don't know. They want to watch the video from the 18th. This was the interview. I'm not sure. Is he still out there?
Who? The foreman?
Foreman. Because it says this was the interview question mark, and I don't know if he's wanting to say first or last or some other descriptive, and I want to make sure I know what he wants. If he's still out there, ask him to step in here, because it goes on to say we would prefer to have this ready once we come back from lunch. So I want to have it queued up. The 18th?
Yeah, November 18th.
Yeah.
It's the first one, Judge.
All right, so the bailiff confirmed that. Next time, bring him in here and let me ask the question, just so that we make sure nobody said anything they shouldn't have said. But the bailiff confirmed that the 18th, the first interview, is what they want to watch. So let's, the body cam video needs to go back to the court reporter if it's still in the thing. And then y'all go ahead and get that queued up for me.
State 62.
Yeah, so that's going to be state 62. And we'll watch that. Y'all be back about 1:15 so that we can get in here and get that done. The bailiffs can go to lunch in shifts so that we can, you and Bob just, okay? All right, we'll stand in recess. Oh, wait. One other thing. we had some discussion, the lawyers and I had some discussion in chambers about whether or not they were entitled to know the count, well, which way the count was going, based on the note that the juror sent out. I'm going to stand by my ruling on that issue, and in doing that, I'm referring to, I'm relying on some language in Smith v. State, which is a Supreme Court case, 302 Georgia 717, which also references Sears, which is 270 Georgia 838. So just for the record, I shared all of the contents of the note except for which way the count was going, and candidly, it was not identified using the terms guilty and not guilty, but was identified in other ways from which I think that is would be the only conclusion the parties could draw, and I don't think that's proper. But I did share the count as to each charge, which I think the parties are entitled to know, and we've responded accordingly. So let's make sure that light's off every time we take a note from them, and we'll stand and recess until 1:30.
Yes, ma'am.
And y'all make sure you're back so that we can
We'll get it taken care of.
play that video as soon as they're all back. So maybe a few minutes before 1:30 in case they're back.